All the agreements which is having the legal consideration will be a contract. Offer and acceptance are the two important aspects, that is the second important elements for a valid contract in the agreement. So if you don't get anything in return out of that particular agreement, then it cannot be a legal consideration. Whatever the objectives or the objects of that particular contract are there, it should not be illegal, immoral. Hello students, a warm welcome to my class. Hi, George William A, Commerce Faculty, Vidhyaashram First Grade College, MYSURU, a temple of excellence. Students, I welcome you all to my class, that is for the Business Law second session. Students, yesterday I was discussing with you about the meaning of contract, agreement, all this. See, what is an agreement or what is a contract? When an agreement is, when it is according to law, automatically that particular agreement become a contract, right? So here, according to the section 10, it says all the agreements, whatever the agreements are being made between the parties, between the two parties, if you want to make an agreement, there should be two parties. A and B, these are the two parties where they are going to come together in order to make some agreement. Now that particular agreement should be a lawful one, or it should be legally formalized, or it should be having a legal consideration. Only then it can become a contract. So all the agreements which is having the legal consideration will be a contract, right? So all the agreements are contracts if they are, very, very important, if they are made by free consent. That is, if I am making an agreement with B, then I should be having the free consent and the B also should have the free consent to make an agreement or to come to an agreement. Right? So that is called as the free consent. There should not be, because I should be knowing all the facts and the materials, and the other person at the other end also should be knowing very well about what is the agreement is being made. So both of us should have the free mind and it should have the same sense on the subject matter of that particular agreement. Then only it can be called as a free consent. And the competent to the contracts, it is not only that we both are giving the free consent about that particular agreement, but we both should also be very much competent enough. We should have that capacity to enter into a contract or for a valid contract. That means both of us should be a majority, should be a major. Both of us should be a major, and both should be having the sense or knowledge about the agreement, right? And we should have that sound mind. We should not be an unsound mind, and we should not be contradicted or formulated by any other laws of the country. Understood? So all agreements are contract only when if it is being of free concern, then having the capacity to enter into contract, and it should be of lawful consideration. Lawful consideration means whatever the agreements you make, it should be of law, or it should be according to law, and it should not be an illegal one, right? The agreement which you make, that should be of lawful consideration and within a lawful object, and thereby it has been expressed clearly void. So if you want that particular agreement to be a contract, whatever the agreement between A and B takes place, if that particular agreement has to be a contract, then there are some important essential elements, we say, important essential elements in order to make an agreement as a contract. The first and foremost is, you can see here, minimum of 2 persons. What is that, minimum of 2 persons? As I told you, when you enter into agreement, there should be minimum of 2 persons. For example, A and B, right? Or it may be Sania versus Sarah, So Sania and Sarah, these two persons may be coming into a contract or making an agreement. So they should be minimum of 2 persons to enter into an agreement. That is the first important element or the aspect of this agreement. So to have a contract, at least 2 persons should come, and thereby one person will make an offer, the other person will accept it. Then only it can become an agreement. For example, if Sania makes an agreement, she will offer something to Sarah and Sarah accepts it, then it is an agreement. Okay? So that is the first important aspect or the element under the essential of contracts. Then secondly, offer and acceptance. Both the parties who are coming into a contract should have the offer and acceptance. As I told you, we have kept 2 persons here. One is Sania and one is Sarah. So Sania will be offering something, or she promises to do something, and Sarah accepts that, and in return she gets something. So offer and acceptance are the 2 important aspects, that is the second important elements for a valid contract in the agreement. So there must be 2 parties in the agreement, right? That is, one party making an offer, the other party making or taking an acceptance or accepting it. So here, whatever the terms, that is, the offer is being made, it should be a definite one, it should be a clear one, clear cut. And the acceptance for the offer also must be an absolute. It should be an absolute one, and it should be an unconditional. If Sania says that she promises to do something, then Sarah accepts it, and it should be an absolute one, and it should be unconditional. There should not be any kind of condition being put for acceptance by the acceptor. That is the meaning. So the acceptance must also be according to the mode prescribed and whatever it has been offered according or communicated by the offerer. Thirdly, we see there should be an intention to create a legal relationship. Whenever 2 persons, that is Sania and Sarah, comes together to make an agreement, then they should have an intention to have a legal relationship, or it should be a lawful relationship or legal relationship, we say. So the agreements which is been made, it should be a legal acceptance, or it should be a legal relationship. So when both the parties enter into an agreement for something, then their intention must be what? It should be creating in the minds, they should create that some legal intention is there between themselves in that particular agreement, right? So if there is no such intention, in case if Sarah and Sania, if they both make an agreement, and in that case, if they don't have the intention of having a legal relationship, then it becomes void. It cannot be a contract. That particular agreement cannot be a contract until unless it has been considered under law. So example you can see here, it is very nice, easily you can understand. It says an husband has promised to pay his wife a household allowance of rupees 3,000. So husband, what he is doing is promising his wife to pay 3,000 rupees for the household purpose. But at a later stage, they got separated. When they got separated, now wife cannot go and ask, or she cannot go to the court of law and say that my husband has not given me rupees 3,000, because it was just a social obligation. It was just a social agreement. There was nothing according to law. The agreement was not made according to law. So thereby that particular case will not be sued, or it cannot be taken into consideration, right? So, but in commercial as well as in business agreement, there is a presumption that usually the parties who are entering into a contract, they should create a legal relation between themselves. They should create a legal relation between themselves, right? Now coming to the next Fourth important aspect or the elements. If an agreement wants to be a contract or a valid contract, then the fourth point says lawful consideration. That means an agreement to be enforceable by law. So all the agreements which has been enforceable by law can be a contract. So there should be a consideration. What is that consideration? Consideration means make an advantage or to get something back. So it says in simple words, you can see here something in return. Consideration means something in return. When you make some agreement, then you should get something in return out of that agreement. Understood? So that's what it says. The argument is legally enforceable by law only when both the parties give the consent, and when it has been enforceable by law, then only it can be a valid contract. So when both of the parties get something in return, it is considered as a lawful consideration. And here it says a promise to do something or else getting nothing in return is not a lawful consideration. So if you don't get anything in return out of that particular agreement, then it cannot be a legal consideration. So example, it says A and B are at dinner. So A has invited B for a dinner. But what happens here? B comes here and A does not host the dinner. B comes to the house of A, and at that time A will not host the dinner to the B. In that case, B cannot sue A just because he denied the party, because there is no lawful consideration, or there is no such any kind of lawful consideration or the acts. Now fifth one is the capacity of parties. Capacity means the competent person who can enter into a valid contract. I told you Sania and Sarah, these both are the two important parties to the agreement. Now this particular persons, that is Sania and Sarah, if they want to enter into a contract, first and foremost, they should be a major. Both of them should be a majors, that is attaining the age of 18 years. Secondly, it says they should be of sound mind. What is that, be of sound mind? That means both should have the sense, and they should know what they are agreeing upon. So both should be having the same sense, knowledge at the time of agreement, or when they enter into the time of agreement, that they are not of unsound mind. They are having a sound mind, and they are very clear about the agreement which has been made between them. And thirdly, it says it is not been disqualified or contracted by law for both of them. So in any case, it may be in the past, present or future, they are not being contradicted, or they are not being contracting by any law which has been subject to the capacity of the contract, which may arise in future also. So these are the three important aspects regarding the capacity of parties. The next essential of a valid contract says free and genuine concern. There should be a free and genuine concern. The concern should be given by both the parties. That is, Sania and Sarah should be of free mind, and they should not have any kind of problem in giving the concern. So the concern which has been given, it should be of free concern, as well as it should be a genuine one, a true one, and it should not be just because of force, or it should not be because of different situation, like it says coercion or undue influence or fraud, misrepresentation, etc. So the subject matter of contract or the agreement, both should be free enough to give free concern, as well as see that they are genuine in giving the concern to the agreement or to the contract. Lawful object. It says the object of agreement. What is the main object of an agreement? Main object of agreement, it should be a lawful one. That is very, very important. The main object of an agreement is what? It should be a lawful one. It should be according to law. Whatever the agreements you make, that should be a lawful one. And it says that means the object must not be illegal. So in other words, we can say that whatever the objectives or the objects of that particular contract are there, it should not be illegal, immoral, as well as it should not be opposed or oppressed by any of the parties or the public policies. Now next is regarding the agreement not declared void. So this also is a very, very important element as part of valid contract. It says whatever the agreement, that agreement must not be declared void by force, by law in force of the country. So whatever the agreements you make between both the parties, that should not be that particular agreement or that particular agreement should not be declared by law. Earlier itself, if that particular agreement which you have made now, if that is been declared earlier according to law, if it is declared as void, then that cannot be considered as a contract. You cannot take into consideration. Certainty and possibility of performance. The next important aspect is certainty and possibility. The agreement should be certain. It should be certain as well as not void or indefinite. It should be a proper agreement, right? So agreement should be, or it must be a certain agreement. As well as it says, example, if A agrees to sell B 100 tons of oil. Now here it says there is nothing whatever to show what kind of oil he was going to sell it. In that case, the agreement is void for uncertainty. What is certain? What is uncertain? Certain means surely it is going to happen. It is going to happen. For example, death. That is certain. We know that. Yes? But whereas accidents or some calamities, these are uncertain. We don't know. We cannot predict when it is going to occur. It is uncertain. So here it says the agreement should be certain. It should be a certain. That means whatever you are going to do, you should do it. In that case, the agreement should be a certain one, and it should not be, there should not be any kind of uncertainty in this agreement. So a very good example is given. It says A is willing to sell, makes an agreement to sell so much of tons of oil to B, but he is not disclosing what kind of oil he is going to sell. Where if he does not disclose the subject matter of that particular agreement, then that particular agreement will be a void agreement. The last one, legal formalities. See here, the contracts made by words, or it should be spoken or it should be written. Everyone knows that. Any contract, it may be made by words, just by speaking with each other. Or it says by words spoken, by speaking, we will make an agreement, we will enter into a contract. Or it is in the form of a deed, a document that is in writing, right? So, in respect to legal effects, it says there is no difference between a contract in writing and a contract is made by word of mouth. So very, very important. It says as regards to legal effects, there is no difference between the agreement or the contract which is made in writing as well as which is by the word of mouth. But however, the interest of the party is that contract should be in writing. Usually, always the contract or the agreement which you make, it will be in writing only, just for the purpose of to be on safer side. To be on safer side, the contracts or the agreements made will be in writing, so that later on, if any of the parties breaches the contract, if he is out of the law, or if he goes against that particular contract or against the law or against the agreement or contract, then you can sue him in the court of law. So for that, you require a proof or the evidence. So that proof or evidence is nothing but the contracts or agreements which you make, it should be in writing only. These are about the various important elements of a valid contract. So students, once again, I will just tell you the main points, all the 10 points about this essential elements of a valid contract. First and foremost is, as I told you, there should be minimum of 2 persons. Secondly, there should be offer and acceptance. Thirdly, it should be intention to create a legal relationship, a lawful consideration. Then fifth one is capacity to the parties to enter into a contract. Then we have free and genuine consent to be given by both the parties, right? Then whatever the agreement or contract you make, it should be a lawful object, and agreement which is declared not void only can be entered as a contract. Then there should be certainty and possibility for performance, and the last one is the legal formalities. So students, these are the important essential elements for a valid contract. This is very, very important on point of examination point of view. It can be asked for 10 marks also, or for 5 marks. So it has a weightage of 10 or 5 marks. Please go through this particular topic regarding the essential elements of a valid contract. So see you in the next session with the other topics. Till then, take care. Have a nice day. Thank you.